Judgment in the matter of SKAT, the Danish Customs and Tax Administration, against MCML.
Lord Doherty will explain the Court's judgment.
The doctrine of issue estoppel prevents a party in litigation from raising an issue of law or fact which has been litigated and decided in previous proceedings between the same parties. This appeal concerns the scope of the doctrine and the circumstances in which an issue estoppel may arise. The question is whether the claim brought by the Danish Customs and Tax Administration, which I'll refer to as SKAT, against a financial brokerage business, which I'll refer to as EDFM, in these proceedings is barred by an issue estoppel because of the dismissal of an earlier claim by SKAT against EDFM in 2018. Danish law imposed a tax on dividends paid by Danish companies. Companies required to withhold tax when paying dividends to shareholders. However, some non-Danish shareholders were entitled not to be taxed, or not to be taxed at the full rate. They were entitled to have the tax refunded by SKAT. Between August 2011 and July 2015, EDFM provided tax vouchers to clients vouching that it had withheld tax from dividends said to have been paid to them. In 2018, SKAT alleged that EDFM had made negligent misrepresentations in 420 tax vouchers, which resulted in SKAT paying refunds to persons who are not entitled to them. Following a preliminary trial, the 2018 claim was struck out by Mr. Justice Andrew Baker as being inadmissible under the Revenue Rule, a common law rule which prevents an English court from hearing a claim brought by a foreign state to collect tax. SKAT did not appeal that aspect of Mr. Justice Andrew Baker's decision, with the consequence that it became final and binding as between SKAT and EDFM. In 2022, SKAT issued the present claim against EDFM. The 2022 claim is also based on alleged misrepresentations having been made by EDFM in 286 tax vouchers, 281 of which had been relied upon in the 2018 claim, and 5 which had not been. SKAT now alleges that misrepresentations in the 286 vouchers were made fraudulently by EDFM. EDFM applied for the 2022 claim to be struck out on the basis that SKAT was barred by issue estoppel from raising claims based upon incorrect statements in the tax vouchers, because Mr. Justice Andrew Baker had decided that the Revenue Rule applied to the 2018 claim, which had involved 281 of the same vouchers, and because it was clear that his reasoning applied equally to the further 5 vouchers. At first instance, Mr. Justice Bright held that the 2018 claim and the 2022 claim involved different causes of action and that no issue estoppel arose. The Court of Appeal allowed EDFM's appeal. The majority held that Mr. Justice Andrew Baker's judgment gave rise to an issue estoppel that all private law claims by SKAT to recover withholding tax refunds paid out on the basis of applications by EDFM's clients conveying incorrect information were inadmissible under the Revenue Rule. Lord Justice Nugent agreed with the majority that there was an issue estoppel in relation to the 281 vouchers, which were common to the 2018 claim and the 2022 claim. But in his view, there was no issue estoppel in respect of the remaining 5 vouchers. The Supreme Court unanimously allows SKAT's appeal. Lord Sales and I give a joint judgment with which the other members of the Court agree. Issue estoppel has the effect of restricting or denying a litigant's access to court to vindicate what is otherwise a good claim. It may also prevent a litigant from raising what is otherwise a good defence to a claim made against them. It is a serious interference with the ordinary right of litigants to present their claims and to defend themselves. The courts have therefore been careful to ensure that the doctrine is kept within narrow limits. For an issue estoppel to arise, the issue decided in the prior proceedings must have been necessary and fundamental to the judgment in those proceedings. In deciding whether an issue was necessary and fundamental to that judgment, whether the issue arose on the parties' pleadings in the prior proceedings is a critical factor. It is only the immediate foundation of the judgment which can give rise to an issue estoppel, not other elements of the prior court's reasoning leading up to the decision. It would be unjust for a party to be barred by an issue estoppel on elements of the prior court's reasoning which went wider than was necessary to determine the case before it. The scope of an issue estoppel should not depend upon how widely or narrowly a judge chooses to frame the reasoning in their judgment. Litigants should not be expected or incentivised to spend time and effort litigating points which are not important to the first set of proceedings, in case they might become relevant in later proceedings. This reasoning is strengthened when proper consideration is had to the role of the doctrine of issue estoppel and to the different roles of the doctrines of abusive process and of precedent. All of these considerations underpin the emphasis upon the narrow operation of the doctrine of issue estoppel from the time of the earliest cases when it was first recognised. The case law demonstrates that the scope of an issue estoppel is not to be enlarged by inference, deduction, or argument based on the reasoning set out in the prior decision, and that it is not to be expanded to cover another set of facts, even if the factual differences are not material in law. The Court of Appeal's decision and reasoning are inconsistent with the principles which we have outlined. The factual and legal basis of the 2022 claim are not matters which were in issue in the 2018 claim against EDFM. The relevant facts pleaded in the 2018 claim were the allegations that EDFM made negligent misrepresentations in the vouchers used in applications for refunds of withholding tax. What was in dispute in the 2018 claim was whether the statements were misrepresentations which were made negligently, and if so, whether such negligent misrepresentations fell within the scope of the revenue rule. This required Mr. Justice Andrew Baker to determine the legal quality or effect in law of the negligent misrepresentations. The 2022 claim contains different allegations that the relevant misrepresentations were made fraudulently. What is in dispute is whether the statements were fraudulent misrepresentations and, if so, whether such misrepresentations fall within the scope of the revenue rule. These matters were not addressed in the judgment on the 2018 claim because those allegations were not made in SKAT's pleaded case. The majority in the Court of Appeal were therefore wrong to formulate the issue to cover all private law claims to recover tax refunds paid by SKAT based on vouchers conveying incorrect information. That was not an issue which was necessary or fundamental to the proceedings before Mr. Justice Andrew Baker, nor was it the immediate foundation of his judgment. Lord Justice Nugent's formulation of the issue, which was tethered to the particular vouchers which were the subject of the 2018 claim, suffers from largely the same problems as the majority's formulation. The 2022 claim should not have been struck out. The appeal is allowed.
The court is now adjourned.